All right, today we are diving into a really high stakes legal case.
We are.
It's the 1999 Supreme Court ruling, People of the Philippines versus Edwin De Vera Garcia.
And it's fascinating because it forces us to draw this razor-thin line.
Right.
You have someone who acts as a lookout during a crime. So the question is, does that make them a conspirator, a full principal, or are they just an accomplice?
And that distinction is everything. We're talking the difference between, life in prison and a much shorter sentence.
That's a huge difference.
So let's set the scene. This case goes back to 1992, the murder of a man named Frederick Capulong.
Yes, and it involved 4 individuals. De Vera, who we're focusing on, Roderick Garcia, Elmer Castro, and the actual gunman, Kenneth Florendo.
And it was brutal. A shooting and an attack with a baseball bat.
So the trial court, they came down hard. They convicted De Vera as a principal.
Based on a theory of conspiracy.
Exactly. The assumption was, well, he was there, so he must have been in on the plan from the start.
But the Supreme Court didn't see it that way. They rejected that finding. So why? Why couldn't the prosecution make that conspiracy charge stick?
Well, it all came down to the evidence, or the lack of it.
Okay.
Their sole eyewitness, a man named Bernardino Cacao, he only testified to 2 things: that De Vera was in the car before the crime and that he ran away after.
That's it.
That's it. And the court was very clear. Mere presence does not amount to conspiracy. You need facts, actual proof of a common plan, not just guessing.
So with that direct proof gone, the prosecution had to lean on something else.
They had to. They leaned heavily on De Vera's own statement, what was called Exhibit O.
But of course the defense challenged it. They claimed torture, violation of his rights, the usual playbook.
They did. But the Supreme Court found the statement was admissible.
Why? How did it pass muster?
Because of the safeguards. The court pointed to the testimony of the legal aid lawyer at Quezon City, Confessor Sansano.
Ah, the IVP lawyer.
Yes. He detailed his entire process. He made sure De Vera understood his rights, he checked him for any signs of torture, and crucially, he testified that he never left De Vera's side during the interrogation.
So the defense couldn't prove coercion?
They couldn't. The evidence of those legal precautions was just too strong.
Okay, so the statement is in. What did De Vera actually say that sealed his fate?
It established 2 key facts against him. 1, he admitted he knew his friends had a malevolent intention, his words, to kill the victim. He knew they were armed.
So he knew the plan.
He knew. And 2, he admitted he helped by being a lookout. He positioned himself a little ways away to see if anyone was coming.
But his entire sentence, his entire future, it hinged on this one specific quote about his intent, right?
Absolutely. The whole case turned on it. He said, and this is the translation, "I did not agree, but on that day it was out of shame and I was forced to go along."
Forced to go along. That's the key. That's not the same as deciding to kill someone.
And that's the legal fulcrum. The court made a distinction. A conspirator is an author of the crime. They decide it should happen. An accomplice is just an instrument. They concur after the decision has already been made.
So because the plan to kill was already a done deal, a fait accompli.
Yes, before he reluctantly joined in. And his role as an unarmed lookout was considered non-indispensable aid.
So he was guilty of, what do they call it, a milder form of responsibility.
Exactly. The final verdict was a conviction as an accomplice, and the sentence was slashed. He went from reclusion perpetua down to an indeterminate term, maxing out at about 14 years.
That is just an incredible difference, all based on that one nuance.
And it affected everything. The civil liabilities were adjusted too. The court even deleted a $600,000 award for loss of earnings because, again, the prosecution didn't provide factual basis for it. Every detail needs proof.
So the big takeaway here is that liability can hinge on the difference between actively deciding to commit a crime and just, assenting to it out of something like social pressure.
It really can. And it leaves you with a question to think about. How often does the line between being a principal and an accomplice rest on what you knew versus what you actually decided? It just shows you the immense power of legal nuance.